No. Okay, and when did you submit that? I'll tell you what.
Not a word, we'll get you called up.
Is there other?
Absolutely. Perfect.
Jason, the explanation is not there. It didn't come through. At least on the laptop. It didn't come through. Say that again.
Renata, is that someone's relative of yours?
Never heard of it.
Okay, so I've seen her like.
There used to be a guy in Roselle whose name was quote unquote Knippen. But as far as I can tell, he wasn't a relative. There were Knippens that settled here in the 1850s, the 1880s. Well, this was somewhat common name in Germany, but they weren't all related by blood. And Knippen is actually a Dutch word. Yeah, it's the verb to cut in Dutch. I don't know.
We could snip in the budget if we had that.
That's right. You could slice and dice it. Thank you very much, Jace.
From a technology standpoint, Jason?
Yep, the meeting's already up and
All
going.
right, perfect. When we hit 7, we'll get started then. Thank you.
What, the password?
No, I was.
I mean, I did mine the first
Did
time,
you?
so.
All is well, nothing. No.
Yeah, I'm gonna probably go on with the next couple of weeks.
Jason?
I just haven't had a chance. Definitely looking forward to it. As much as I can look forward to that.
Which
Okay,
is okay.
got mine at the CDH. And I'm with the Northwestern Medical Group, but they said just go to Osco. I prefer going to a doctor.
Somebody else.
Yeah.
See, the Osco, do they make this different?
I don't have any idea what they do. I've never been to Osco for a year.
So no, they make you sit there,
Yeah, I
watch
just-
over you. They got a couple medical people there in case something.
I actually don't know.
Yeah.
We good on that end? All right. It's 7 p.m. At this time, I'd like to invite Boy Scout Troop 408 for the posting of the colors.
Will the audience please rise? Color guard attention. Color guard forward march. And salute. Color guard halt. Prepare to post the colors. Post the colors. Will you please join me in the Pledge of Allegiance? I pledge allegiance to the flag of the United States of America, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. 2. Color guard, return to rank. Color guard about face. Color guard forward march.
All right, thank you so much, Troop 408. Now, if you'd all like to come back real quick, we can get you your certificates for participation. All right, so could I have Sean come up first? Followed by Tegan.
Thank you.
Jacob.
Thank you.
Sorry, Newstead. Jack.
Thank you.
Kyle.
Thank you.
Nicholas.
Thank you.
Jacob M.
Thank you.
Aaron.
Thank you.
Joseph. Got it. And that's, if we didn't have your certificate, I apologize. If you don't mind, Marianne, could you send us their names and we'll make sure we get it printed for you guys. Thank you. Madam Clerk, could I have a roll call, please?
Mayor Polisky,
Here.
trustee Berkshire,
Here.
trustee Delapenna.
Here.
Trustee Domke,
Here.
trustee Lanisa,
Here.
trustee Prokowski,
Here.
and trustee Trejo.
Here.
You have a quorum.
Thank you so much. Presentation of the prepared agenda. Do I have a motion to approve? Do I have a second? All those in favor, please signify by saying aye.
Aye.
All those opposed, nay. Any abstentions? Seeing none, that motion carries. We'll now move to village board public comment. Anyone wishing to make a comment on a topic or agenda item may address the village board during the public comment and public hearing segments of the village board meeting. Members of the public can submit online, via phone, via email, or in person. Tonight, we received 3 in advance. I'd invite up Patricia first. Huntington.
Good evening. Can you hear me?
Could you speak just a little bit closer to the mic? Or if you would prefer to remove it, you're absolutely welcome to at the podium.
Hear me now?
Yes.
I have several questions regarding the Lexington Home project. First of all, I want to know, were the homeowners associations, especially Pembroke Estates, Turnberry, alerted in advance that this project was going to go forward? The homeowner associations and the management companies.
Sure. Do you have a series of questions or?
I have about 4.
Okay, would you like to see? I mean, Karen, do you want to address that question first? Our community development.
So for the public hearing that took place before the Plan Commission in May, notification occurred to all residents within 500 feet of the property line of the subject property. So they were notified, and we also have been speaking with Pembroke HOA in relation to some other public utility work that needs to occur.
So they were notified.
Mhm.
I have a little hearing difficulty in this here. Second, I live on the corner of Rodenberg Road and Travis Parkway. They have staked off the back area of my backyard for doing some utility work. I was not notified of that whatsoever. That's an area that I walk 4 or 5 times a day with a dog. That's a very anxious dog that does not like strangers. So I want to know, how is this going to affect me?
The utility work specifically?
Excuse me?
The utility work specifically that's being done?
I can't hear you.
Sorry, are you talking about the utility work that's being done and how that's going to impact you?
Yes.
Kristen, do you have any information regarding that?
Yeah, all the utility work that's being done is being done within the village right of way. So there was no notification to the homeowners as it was within our right of way. The utility work should be done by winter in this location, so it should just be a short term.
Will the sidewalks be closed off?
I am not sure at this point. I believe if they were going to be closed off, they would have been closed, but I will follow up with the developer.
That, knowing that, because I walk that path. So I'd like to know that. Third, I would like to know, are they going to do a better job of flagging men out there on the area? Because there was almost a car collision right in front of me as I was walking down Rodenberg Road last Tuesday, when the electrical vendors or contractors were out there and had parked on Rodenberg Road pointing south. And there were cars, or trucks rather, also in the parkway, so that when people were trying to turn left, go north off of Travis, they couldn't see. There was nobody out there flagging, controlling the traffic flow at all. It would have happened right in front of my eyes. So I want to know if that's going to be a case, because I also tried to use the crosswalk that was there, and the trucks were in the crosswalk. They're not supposed to be in the crosswalk.
And is that in relation to the utility work being done, or is this,
Utility.
okay, Kristen, can you follow up with the contractor to,
That work was ComEd, that was independent from the development. It was a separate ComEd utility permit, and
Yeah, I didn't
we,
see comment on the trucks. It was some other vendor.
yeah, it's probably Intren is who does the majority of the work for ComEd. So
It's very dangerous. I believe it was Lexington Home had 3 large tractor trailers parked on Rodenberg Road pointing south, which then, if you know, the road is very small and narrow. People are trying to use the turn lane to drive south, and people are trying to get in the turn lane to turn onto Travis Parkway. So we need somebody out there when there are these trucks patrolling the traffic.
so, Kristen, let's provide that feedback to ComEd for their work, and, we'll continue to work with Lexington Homes on the proposal and make sure that that is being addressed. And I think there's a representative from them here tonight as well, so they're hearing your comments, so.
That would be great. My other concern is when you're talking about widening Rodenberg Road, how are you going to do that?
So at this point in time, we're not planning on widening Rodenberg Road. We're doing a complete rebuild of it because of the substrate condition of the road. We would be putting in proper curbs. So in some sense, the road might be slightly wider, but not in the sense of we're adding lanes to Rodenberg Road. It'd be the same car traffic as it currently is built for.
So will there be a traffic light put up at all?
At this time, no, there's no plan for a traffic light.
There are a lot of speeders on that road that also add to the congestion and the problems that we're facing living in that area, because we believe that we're getting an awful lot of traffic trying to avoid paying tolls on the Elgin O'Hare. So we have an increase of traffic. So we need to have that addressed, because I understand there was a study done, but I don't know, was it a 24-hour study? Was it a workday study, a weekend study, that kind of thing makes a difference.
Right. Usually these studies are pretty well encompassing, but we'll work with the police, the chiefs here tonight, so we can make sure that we enforce and update our speeding enforcement in that area. So appreciate the feedback tonight.
Last question or suggestion. There are pedestrian warning signs on both sides of Rodenberg Road that people blow through. And can you maybe get those to be flashing signals so that they understand that there's something, because people ignore signs, like right out front here when I came to park, I backed up, I couldn't see any sign, there was no posting, and I was in a handicap spot, so I moved because I don't park in handicap spots. So people don't always do that. And when I'm trying to cross that street, you're taking your life into your own hands.
Public Works is currently evaluating different pedestrian kind of crosswalk control mechanisms available to us. We have some concerns with some of the flashing due to liability constraints and also kind of ownership of roads and whatnot. So we're continuing to evaluate it. I'd say, Kristen, let's add this intersection as just an area to continue with our evaluations overall.
Yeah, it's late at night when I'm walking, they're flying through 50 miles an hour. So we need to do something because that is public safety. I'm out there at night walking my dog and I don't want to get hit by somebody speeding through trying to get through the expressway. So I would appreciate some concern for the residents for our safety.
Okay, thank you so much for your feedback tonight. Next, I have Kathy Barnes. Sure, absolutely. Now we can really hear you.
Can you hear me now?
Oh yeah, that's great.
And I can hear both my ears. I live in Hampton in the Park and I'm very upset about it. I'm on the HOA of Hampton in the Park. I'm one of the persons that have been hit almost 3 times crossing that Rodenberg. You guys did your study during COVID and said it wasn't busy because I was in the last Zoom meeting about this thing. People coming up Travis look left and right, not forward. I've had cars this close to me. I'm with 2 big golden retrievers and they're almost hitting me. Now you have all this other traffic. You got 64 townhouses you're put in, which probably 2 cars per person. You're adding 100 and some more cars that are going to be on Rodenberg, which is a crappy road to begin with and falling apart. And you have all this heavy traffic now that is tearing the road up even more. Number one, you pulled all those shrubs out. We've got everybody upset in the neighborhood. I can now see the train, the crossing, hear everything because there's no blockage of anything. It's ridiculous. You guys are tearing up, you tore up all the animals back there. Who knows where they are? We have owls, coyotes, foxes, everything else that are now displaced. We have no idea where they are. I pay over $14,000 a year property taxes. And I bought a private community and now it's no longer very private because we're looking all the way to the railroad tracks. And I'm kind of upset about the taxes I pay and then this is what I'm getting. And I've told you before about this trap. It's a lawsuit. And I've told my husband, if I get hit, sue. Because I'm looking both ways and those cars are coming up and they're turning right into me. So something needs to be done about Rodenberg now, even with all that construction that's going on. Plus, I think you got a lot of homeowners upset from Hampton in the Park on there, what you've done. You've tore up and you changed the rules every time some contractors want something, you've changed the rules. And we have people very concerned about the water drainage. Who's going to spray for mosquitoes now back in there? Because that's a water area back in there. So that's my concerns right now.
Okay, thank you so much for your comments tonight. Brian?
Name's Brian Herzing, 1040 Bluebird. I've kind of have a mixed feeling about the whole construction thing. I'm on the board of directors too for Hampton in the Park. I was initially approached by Karen about this construction, and I actually have her correspondence here. Basically, most of the people's concerned are about the construction itself and Rodenberg and water pressure and so forth. What is this going to do to the drainage overall? I had a question about the land at the south end corner of the property, which is going to be the retention outlot D. And it says the existing natural area in Outlot D. This is a correspondence from the village planner in March. This is the initial approach to the first thing I'm hearing about the improvements. Existing natural area in Outlot D is proposed to remain as it exists today. Minor grading work will be done for the compensatory storage. However, their area will remain a natural habitat. So I would like to show you guys. This is my backyard. Before and after, and I'll have you guys. So, so basically, by the time I knew about this, and I understand, you know, that this is a complex thing and it's not easy to get this done because of all the constraints and you know, it's a difficult piece of property. So at the same time, I'm bringing this to you, I applaud the efforts to develop the property, to increase the tax rolls and to try to fix the water drainage issue. So that's on the plus side. On the minus side, I'm not okay with the destruction. I don't think that the village zoning board really considered the noise issue. It was brought up and tabled immediately saying, oh, it's not an issue. But now I can look out from my yard, I can see the train, I can see the airport, I can see the backyards of all the properties on Garden. So how do we get, I would have wished that I had advance notice before the drawings were done, because I understand that they've got to go to back and forth to the county, and then stuff gets locked in along the way. And unfortunately, in the process, you know, we lost some trees which could have been possibly saved. I don't know about that. And it's not on my land, so I understand I don't have complete control of that. But going forward, I've reviewed the plans about maintaining the land. And I want to make two comments. One is that it only looks out 3 years. Past 3 years, it's just a general maintenance plan, similar to what we have at Hampton in the Park, and nothing addresses the trees. According to my calculations, they took out 150 trees, 150 things worth noting in the survey. I counted them. They're only putting in 39 trees. And the way these are drawn, if you gentlemen, ladies, these are 20-foot diameter trees. These are not the actual trees that they're putting in. These are an artist's representation of a tree, which may or may not reach this size in its maturity. So you took out basically a thicket and we're replacing it with something that's going to look like Morton Arboretum. So all those animals these are going to be 2-inch little cuttings that are spaced effectively more than 30 feet apart. So I don't see how that's going to offer any sort of natural habitat for any foreseeable future. And also considering that going out past 3 years, that there's no really plan, as far as I can see in reading this, to deal with the trees that are planted. I think that we should lean a little bit heavier towards overplanting rather than underplanting. And I would actually recommend that they double up on the trees that they plant, because I am convinced that currently, you know, I planted trees in my yard that didn't take. These are not going to be managed, and I think some of them will die. And I would like to see at least this many survive going forward, if not more. So I would recommend that the village double the requirement for the planting in this area at least. And then should the need be at a later date, they realize, oh, if these are doing really well and they're too close together, we'll cut one of them out. But the way it's looking, it'll reset if something dies. At 3 years, they'll just plant a stick, say we're done, it's alive, we're done. And then the HOA will be on the hook for replacing it, and they won't want to replace it. So that's my 2 cents. Thank you.
Thank you so much. Do you have any other members of the public that wish to make a comment at this time? Yes, sir. Please come to the podium and just introduce yourself and your address if you're comfortable.
Mr. Mayor, council members, my name is Robert Hossa. We have been living in Roselle for 43 years. I'm concerned with problems that my neighbors have recently had. They had sinkholes in the street in front of their houses this past year and were charged between $8,000 and $15,000 each to repair for homeowners. The properties are located at 45 and 52 West Rosemont and 48 and 49 West Rosemont Avenue, which is incorporated on the west side of Roselle Road. The reasons for the sinkholes were because of sewer lines. I guess they were old and they just cracked, and then I guess everything gave out. And this happened at two locations about 6 months apart. Myself and all of my neighbors have never heard that we were liable for street issues. Since this is an ordinance, section 2249, section 22-58, and section 2259, we need to be aware of these issues. We do not come in here, buy a house, and read all these ordinances and say, oh, this is fine. Because this is, we're not lawyers. We're just normal people working every day. And myself, I'm retired right now. And if you came up to me and said, I got to repair the street for $15,000, I would tell you, I can't. I'm on a fixed income. I made my life, I'm comfortable, and I'm living out my life until I die. Why don't capital improvements in our water bill cover these issues? Because that is what's supposed to be covered by old and faulty sewer lines. And, I've been paying, I know when this capital improvement came years ago and they said, oh, it's only going to be for 5 years or something like that. That's what we were told. And okay, fine. I'm fine with this. I will pay this and not have an issue. But if we have to pay for something that's outside of our, in the street, that's something that should be make us aware so that we can handle this, because there is outside insurance that you could purchase. It would be nice if the board could come up with something that, there is the home serve. I don't know if anybody, I looked into it. I called my insurance company. They said, yeah, they don't cover it, but more and more villages are doing this. They're charging residents for sewers that, yeah, they're clay tiles and life expectancy is what, 50 years? Well, you know what? Let's face it. If you live in a town and you stay there and you're happy with it, you're going to live there more than 50 years, if we're lucky. And one other thing I've noticed, we have a lot of semi-truck traffic going through our side streets, which can damage our streets, which will cause damage to the sewer pipes. Because these semi-trucks, they're looking for the industrial park, or they're trying to skip Irving Park and cut through. And I've seen this over and over again. Okay, fine, if they want to do that. But then again, that's putting strain on our streets, especially the side streets. These are not zoned for heavy-duty traffic to be going through. There were a few sewer line repairs in the village, in my neighborhood, and homeowners were not charged. One was on Granville Avenue from Roselle Road to Lincoln Avenue. They had new sewers and new pavements, and it was no cost to the homeowners because it was old. Well, these streets are old. If all of a sudden they have a sinkhole, they should have been repaired years before. We shouldn't be waiting until all of a sudden, hey, we got a sinkhole. Oh, we got another sinkhole. And, it's, to me, like I said, I'm retired. We have a lot of families that are young and they're trying to make it. We shouldn't put this burden on them. And in closing, I just mentioned 3 sections in our ordinances. I just wonder how many more that there are that would cost us money that we don't know about. Because these ordinances, you know, if you buy a house, I'm not going to look at 100 ordinances and say, oh, this is, oh, I got to look at this. I'm not a lawyer. Okay. And it would be nice if, even if the village could come up and say, hey, we could get, pay $10 a month more, and we could get this home serve to cover our streets, if that was the case. Because there's got to be something that could help us. Because we're all living here, we're all working together. And that's my spiel.
Thank you, sir. I know we'll have the police kind of look at the semi-traffic in that area to see if there's anything we could do. Kristen, I know there's tens of millions of dollars in water main and sewer main replacement that we need to do. We don't have tens of millions of dollars to pay for it. Granted, that's another story. But Kristen, can you comment on some of the policies and whatnot?
Yeah, so I believe we spoke on the phone previously, and the concern is that the sanitary sewer is the homeowner responsibility from the house to the main and the connection point at the main. So these issues that occurred in the street were a result of the failure of that connection point and a failure of the service. So that, per the code, as you referenced, that is the homeowner responsibility from the connection point all the way to the house. The work that you referenced on Granville was actually a water main replacement. And the policies with water main are different than they are with sanitary sewer. It's a different pipe. For about 50 years. That's the current
Currently, our
ordinance.
policy as is. So, I mean, it would take an action from the board to change that. And so, appreciate you sharing that here tonight with us. And, the board can take that and decide if they want to make any amendments to that. So,
I would appreciate if they would tell us homeowners, because there is insurance out there. I mean, I don't want to pay extra insurance, but if I had to, it's better to pay $12 a month, $20 a month than $15,000 in one lump sum. Thank you.
thank you so much. Is there any other public comment tonight? Seeing none, we'll move to officials and staff reports under mine. Before we move to items 6A1, just a reminder to the board to get back to Jason about our meeting schedule for the rest of the year. So we have to approve the budget for next year. And so we have a couple options on the table. So please make sure to follow up with him. For consideration for the board tonight, I have approval the formation of an ad hoc centennial commission to assist with the activities to commemorate the Roselle Centennial in 2022. Is there a motion to approve?
So moved. Second.
Any discussion? All right, all those in favor, please signify by saying aye.
Aye.
All those opposed, nay. Any abstentions? Seeing none, that passes. Other than that, that is all that I have under my report. Are there any trustees that have a report tonight? Trustee Domke.
Now, in light of all the heavy things that are going on in the village, I got a couple of light ones to share with you. What day was it? Thursday, October 7th, the 99th birthday of Roselle, we signed a letter of intent with the village of Lotz, Germany, to be a friendship city for the next year or so. And that's gone down. And then a day earlier, we met for the first time with a group of Indian citizens from India that live in Roselle. And they wanted to also seek a sister city in India. So, I mean, it's kind of weird that we would be doing this much activity for a small town. And when you have volunteers that have a heart for something, you just don't turn them off. So we welcomed them in, and we're going to start pursuing something like that. So I know it has nothing to do with some of the heavy topics that have hit so far, but still fun. So that's what we're doing.
All right, thank you, Trustee Domke. Any other trustees? Moving to village clerk,
No report.
village attorney.
Mr. Mayor, I don't know if you want me to address some of these issues now, but there are issues associated with the Timberleaf subdivision, which is agenda item number 9 under community development. Would you like me to deal with those things now, or would you like me to wait until then?
Let's do it when we get to that agenda item if
Be
you're
happy
okay
to
with
do
that.
that. Thank you.
Thank you.
I have no further report.
Perfect. Village Administrator.
No report.
All right, we'll move to unfinished business. First, we have the consent agenda. All items on the consent agenda are considered to be routine, procedural, informational, self-explanatory, and non-controversial in nature. These will all be enacted in one motion. There will be no discussion of these items. For tonight, we have presentation approval of the village board meeting minutes of September 27th, 2021. Adopt a resolution affirming the purchase of holiday decorations in the amount of $53,666. Adopt a resolution affirming the mayor to execute a contract for partial roof replacement at Village Hall and the fire department in the amount of $151,647. Adopt a resolution authorizing the mayor to execute a contract for the purchase and installation of waste activated sludge improvement electrical components and SCADA programming at the Boderman wastewater treatment plant in the amount of $17,200.82. Adopt a resolution authorizing the mayor to execute a contract for the purchase and installation of waste activated sludge improvement mechanical components at the Boderman wastewater treatment plant in the amount of $13,275. Adopt a resolution authorizing the mayor to execute a contract for the painting of the vehicle storage and mechanical garages at the Public Works Building in the amount of $45,475. And adopt a resolution requesting that the village will be allowed to participate in the Cook County no cash bid program for tax delinquent properties. Is there a motion to approve? Thank you. All those in favor, please signify by saying aye.
Aye.
Those opposed, nay. Any abstentions? Seeing none, that motion passes. We'll now move to community development. Trustee Berkshire.
Thank you, Mr. Mayor, I'd like to make a motion to open a public hearing for the amendment to the annexation agreement for 7 North 601 Rodenberg Road.
There's a second? And can we do a roll call, please?
Trustee Berkshire.
Yes.
Trustee Trejo.
Aye.
Trustee Prokowski.
Aye.
Trustee Domke.
Aye.
Trustee Lanisa.
Aye.
And Trustee Della Penna.
Aye.
That motion passes.
Thank you. So I'd like to make notice that a public notice statement was made in the Daily Herald on September 24th, 2021. And that also that same notice is on file with the village clerk. With that, I'd like to move to public comment and ask if any member of the public wishes to ask questions of the petitioner or the village staff. Seeing none, I want to see if any member of the public or audience would like to speak in favor of the petition. None. Is there any member of the public who wishes to speak against the petition? Seeing none. Are there any questions or comments from the board? Seeing none. Oh, yes.
I'm just wondering about the, what the attorney's gonna talk about with the changes. Should we do that now or after the close of the public hearing?
You can do it either way. Either's lawful. Whatever your preference is.
I mean,
What I'm going to talk about, Lee, is I'm going to talk about the annexation agreement. We had a draft annexation agreement that went out from staff with regard to the development of the project. And it's come back with some proposed changes from the developer. And I'm going to talk about those proposed changes. I am going to probably clarify some of the questions that have arisen with regard to the 3 years that the gentleman brought up tonight, because I think that there's a somewhat of a misunderstanding of what that 3 years means in the context of the agreement, because it means more than you think it does under the law, but I want to explain it. It may mean less than you think it is too, but there's certain laws and regulations associated with wetlands. And that's what this really governs under the circumstance. It's a wetland parcel and it's subject to certain regulations. So those are the two primary areas, Lee, that I intend on addressing in my comments. But they all relate to the amended annexation agreement. So whatever your preference is.
I mean, I prefer hearing it during the public hearing. I don't know what everyone else thinks.
Sure. Okay. So in any event, firstly, just to make some quick comments with regard to the natural areas, which are encompassed in the annexation, amended annexation agreements, lots C, D, and E in the agreement. The county had identified those because the property is currently located in county as a wetland parcel. And as a wetland parcel, they have a legal status that exists outside other natural parcels. Wetland areas are entitled to greater protections under the law than, say, for example, a savanna area of a woodland or something like that. And it's because of the benefits that are derived from wetland areas in terms of filtration of water, being able to hold and retain detention or retention, protection of certain endangered species if the endangered species exists there. Wetlands are graded in terms of their quality, and the county evaluates those things to determine whether or not any special regulations would be in place to protect it. And it also rises in the context of water quality. And the reason for that is under the Clean Water Act amendments that were adopted by the federal government, one of the mandates was to clean groundwater, and wetlands clean groundwater. So they kind of are all wrapped into a package under the law to try to provide the protection. The 3-year period of time that's identified in the annexation agreement is what I'll characterize as a monitoring period. It is not what I'd characterize as it's 3 years and out. It's an initial monitoring period that's undertaken by the county and by wetland biologists, where the area is inspected to make certain, or to attempt to make certain, that the area is being developed in such a way as to not compromise certain wetland species that are protected under the law. And so the wetland species that may be compromised are enhanced by planting certain wetland species that they deem to be appropriate to either reestablish or to protect the wetland area. Classic example is a group of plants called sedges, which are a type of grass. It's a wetland grass, and what it does is it can survive in both wet and dry conditions. In fact, they typically go through a wet period and then they go dry, and they're still able to reproduce. They protect the shorelines against erosion primarily, and then they have a variety of other different biological benefits as well. But for the 3 years, they have companies that are hired to do these kinds of wetland restoration work. And the county will send out periodically inspectors and things like that to look at the wetland site to see whether or not it is being enhanced in conformance with wetland law. After the 3 years, however, that doesn't mean that that obligation ends. Quite to the contrary, under this particular agreement, it continues to exist. And it's in the annexation agreement as well as the ordinances that are adopted by the village, which go beyond the 20-year annexation period. Still requires enforcement, but it goes beyond that period of time because you'll know that we've got a backup SSA here. So if the homeowners association does not come forward with the funds to pay for the wetland maintenance, the SSA taxes can be imposed on the homeowners.
And what's an SSA?
Special service area. It's essentially a special tax for a specialized governmental purpose, and it's established through the Illinois Constitution as well as state statute. And basically, there will be a backup SSA in this case that'll be adopted by the village board after the developer takes possession of the property to make certain that in the future, if the homeowners association fails to follow through on what it promises to do in the agreement, which is allow the inspection, maintenance, and restoration of that area, the funds will be available to do it. So that's in the agreement, and as a matter of fact, the agreement very specifically states that that SSA cannot be terminated without the village board's approval. So it's essentially an SSA in perpetuity, and the village board certainly could do that, but then you've got an issue out there associated with the diminution of that wetland as it may affect the drainage issues associated with the use of that as parcel water drainage control in this area. So, you know, I'm not going to sit here and tell you that this is perfect, that it doesn't have to be enforced. It has to be enforced to make it work. But anything like this has to be enforced to make it work. It just doesn't enforce itself. That's number one. The other thing is that I want to make note of here is, and the gentleman, you know, I love trees, just so you know. I've got a lot of trees in my yard, but wetland trees are special species. Certain areas around wetlands called savannas are specialized. And just willy-nilly planting trees in a natural restoration area may not serve the ultimate purpose of the restoration purpose that's specified in the law. So, the trees that are here, at least under the current designation, from what I can tell, are probably have been determined by the county as being the trees that are necessary under the circumstances in order to satisfy the wetland regulations and requirements. And right now, the county is in control of that. The county has been very active in seeking the protection of this area for the purposes that I've just articulated. That's just kind of a little bit of background into what we're dealing with here and what the village has attempted to do in the amended annexation agreement to provide the protection and provide the funds in order to be able to accomplish the end goal of the maintenance and the restoration of that wetland area out there. You can, under the law in certain circumstances, you can change a wetland and then restore it. And I don't know what the case is in this particular case and whether that has or hasn't been done, because generally attorneys don't get involved in that kind of detail in this kind of situation. So I don't know, I'm sure what the gentleman describes in terms of what he sees out there is accurate. No, I understand that, and I think I addressed that by saying the protection of the trees is not necessarily protection of the wetland area. Certain types of trees under certain circumstances can Correct. There's not. And that's because there's flexibility that's incorporated into these plans. So as the plans go forward and as the area evolves, the biologists and the people that are supposed to be maintaining the property can make better judgments and determinations of what is and what is not going to be installed. That's my understanding of it. It's not a static kind of situation, which is once you make a decision, that decision is final and you can't alter or change it at some point in time. So long as the underlying basis of the plan is maintained. What I can tell you, for example, is when I was the attorney for the Forest Preserve District would periodically, in the restoration of sites, make decisions, for example, as to what kind of trees they wanted to be put in. The trees died, and then they determined that because of the soil makeup and things like that, those trees just weren't appropriate for that area. They went in and they planted other trees that were more adept to surviving those areas. So, I can't tell you exactly what the county's done in terms of this particular plan because that's not my area of study, but that's the overall intent here, and it's encompassed in this agreement. There have been issues now that have been raised with regard to the village's ability to enforce this. We've got the backup SSA as an alternative to the backup SSA. When I originally wrote this agreement, I had some language in it that said if there was a legal challenge to the SSA, the village could essentially say, okay, you're not annexed any longer, we're terminating your sewer and water. The developers asked that that be stricken. And when you get right down to it, it should be stricken. And the reason it probably should be stricken is because it's a little bit harsh. It's going to affect the ability of homeowners as well as the ability of the developer to secure financing, because the bank's going to look at that and go, my gosh, what's going to happen if, the screw up here. So, I understand that. The origin of that, just so you know, comes from our individual homeowners annexation agreements where we've got similar language and don't have the same kind of economic or financial issues associated with that. The other thing, though, they did, and so I don't have any problem with striking let me see, it would be the last sentence of the second whole paragraph on page 8. They've added a paragraph that says that the only time that the village can assert in pursuing enforcement of payment, if the village pays for the wetland restoration as an option, which it could do if it wanted to, that it would permit the village to sue and secure a lien against the property and foreclose on the lien. And they want to strike that. But they agreed to that as long as it said prior to the sale of any units in any lot. That is something that I understand why they did that. But it seems to me we needed some protection there, and we can include that language in there so long as the developer agrees that if the village has to pursue legal action in order to enforce its rights under this agreement, that the homeowners association, or what's known as the independent association under the agreement, has the legal obligation to reimburse the village for its attorney's fees. And what that does is that increases the cost of trying to defend that kind of thing and generally makes it a not very favorable business proposition to defend, and puts the village in a superior position in terms of negotiating leverage, which in my opinion in this circumstance would be appropriate. So I could agree to that language in this, I could recommend agreement with that language in the second to the last sentence on the first complete paragraph on page 8, so long as even after the sales of units of lots, if the homeowners association fails to honor a village request for reimbursement of village funds used for wetland inspection, maintenance, and restoration, that they're going to have to pay our attorney's fees if we have to use legal action in order to accomplish that. That shouldn't have that great an impact on the individual property owners in there, or the developer who will be out of the picture at that point. It'll be the homeowners association.
So with that being said, when I look at 9C, there are changes to that amendment of which you're in agreement with, but then there are also changes, what I'm hearing in that agreement, that we need to go back to and have the developer agree to. So do we table 9C as a result of? Because that is not a final and official document until they've also agreed and you've come to consensus.
I think that that's appropriate, Bruce. Yes.
Okay.
You don't table it though, because if you table it under Robert's Rule of Order, you actually kill the item. You'd continue to a date.
Continue it? Okay. Then we will do so. All right, is there any other questions? Yes.
One, can we put a mechanism similar to what you just described about recapturing our legal fees to the first item that you had? You know, if the SSA is deemed illegal, can we put that same caveat in that?
Probably not.
Okay.
But here's the way that the SSA works. The SSA is subject to a reverse referendum, and the reverse referendum under the law has to be brought within 90 days of the date that the SSA ordinance is passed. Well, this developer will be the owner at that time. And as a consequence, you're not going to see the owner file a reverse referendum under these circumstances. And if they do, we can, Tom, put a provision in the agreement that says that if they challenge by reverse referendum after the SSA ordinance is established, the developer will have to suffer some kind of legal consequences that will make an extremely unsavory thing for them to do. But I can't imagine that they'd even consider doing that. Because it would basically be saying, okay, pass this for me and we'll agree to the SSA, but then turn around right away and say, but you know what? We didn't really agree. We had our fingers crossed. I don't think that's going to happen.
So now thinking about this a little more, Jim, since we're still in public hearing, should we just continue the public hearing and then pick up 9C, D, E, and F at the future meeting and then close the public hearing at the next meeting? Or should we close the public hearing, continue to the next meeting, 9C, and then I would read, as I read 9D and E and F, we could actually get those.
The latter instead of the former. Close the public hearing. Because you've taken your public comments at this point.
Close the public hearing, continue 9C to the next meeting, but we can address D, E, and F in this meeting because they seem to be unrelated to the actual annexation agreement. It's all about the development plan, the subdivision, and the actual village clerk to improve that subdivision.
Yeah, my recommendation would be that 9C, D, E, and F
We
all
can
be continued.
Okay, thank you.
to the next meeting. So it's approached as a unit as opposed to piecemeal.
That's what I want to double check.
Yes, as to what.
Nope, I wanted, that's why I kept reading and looking at that. We were talking 9C. All right, with that, is there any more questions?
I would just like, we do have the developer here, so I think I would just like to see if they have any feelings on it. And unless there's any red flags on their end, I just want to make sure they have an opportunity to speak, if that's all right.
Sure.
Everyone. My name's Mark Iden, I'm from Lake Barrington. I am the attorney for the developer. And I'm a little hard of hearing, even though I have my hearing aids in. Could you once again explain to me what the proposal is with respect to the annexation agreement?
The proposal of the annexation agreement is to accept the changes that you've made, except to supplement the first whole paragraph on page 8. It says that if upon submission of a statement for services for the maintenance or the restoration of the SSA, I mean, not the SSA, the wetland area, and the homeowners association does not pay it, and the village has to seek legal action, even after the sale of units in a lot, that the homeowners association will be responsible to the village for attorney's fees.
I would think that the homeowners association would be. The only concern I had was an attempt to lien
Individual ownership.
the units after they had been sold. I don't mind a lien while the developer still owns.
Then we'd be in agreement on that once we render some language, Mark, that would be acceptable to both sides.
Okay, I mean, I don't really see any issue with any of that. So we have to hold open the execution of the amended annexation agreement.
Terrific, yes.
Will that impact any of the ability to go ahead with site development at this point?
I mean, I will step in and just say, I don't think we have, unless you're annexed in, we have no jurisdiction over the property to lend any site plans or anything of that nature in my mind.
It's already been annexed.
Oh, it has? Okay, so this is just the annexation agreement. So in theory,
It's an amendment to the annexation agreement, Mayor.
So I'm sorry, what would be the answer then to that question?
it's the board's personal opinion. So I think there's at least, I think, I think there's two things that the board needs to consider first and foremost, and it's just whether or not they want to continue this to the next meeting, in which case they can make that decision, then approach the second piece of it. So
If you, based on my recommendations, if you want to you want to approach it by saying, we'll adopt these subject to the village attorney's final approval, that's another option. And then I'll go in with counsel and we'll wrap it up with regard to what I'll characterize as those technical details.
Yeah, I believe we're in agreement on what's to be done. It's
The other thing I want to look at, Mark, is I want to look at all the changes you made to developer and owner, because I want to make sure that owners are bound by the terms of this agreement.
what I tried to do. I was thinking in terms of the developer and the owner being the same entity.
And then I want that specified, which will be very easy to do.
Yeah, well, what I did is I just referred, it says the developer is now the owner, which they are. And then I used the term developer consistently.
Okay, then we're good. I just came back from Door County at 7 o'clock tonight, so.
So is the issue that the annexation agreement can be approved this evening, subject to the attorney's final approval?
That's okay with me if it's okay with the board now that they've agreed to that language that will essentially make them have an attorney's fees obligation if the homeowners association fails to reimburse the village for costs.
And that's not.
Personally, it seems like we've got a couple of gaps. You've got some additional reading to do, ownership and the like. We've now got this. You're having council discussions in the board meeting. I would much prefer to continue, but I'll look to the rest of the board for their direction. And I mean, they're already annexed in, so they can continue doing the stuff that they're doing, correct, Karen?
Yeah, per the direction you guys gave at that meeting in September, we issued the land development permits subject to some conditions, which they've continued to meet. So there should be no issue with continuing land and grading and site work on the property.
So, and that's
Again.
really our concern, because if we have to wait another 2 weeks, we're going to have to stop and reevaluate for spring. It's just that time is so tight before winter conditions settle in.
Understood, but I think we've agreed to that, allowing that already. That's underway. We're not changing that. I'm just not comfortable with approving or making a motion to this until we've gotten all of the language worked out and wrapped up, because it may not wrap up. And we're still in conversations at this board meeting on that annexation agreement.
So the original annexation agreement will remain fully applicable.
Addendum.
Work can continue under that original annexation.
So,
All right, so that would be the next board meeting then?
well, as long as the rest of the board is okay with.
As long as we're not putting a hold on your work, I have no problem waiting until the next meeting to see the final documents.
I mean, I'm okay with either way. I mean, obviously it sounds like it's a couple minor tweaks that they're agreeing to right now. So I would be comfortable. I mean, we've done this before. We approve things with the attorney's approval. Obviously, Jim is representing our interests as the village attorney, so I'm comfortable doing it. But, you know, I guess it doesn't sound like there's a risk for construction, so I don't have a strong feeling either way, but I would be comfortable with wrapping it up tonight.
And I can get this addressed tomorrow.
Okay, but if we do that, though, it won't be approved until the next board meeting?
It depends.
Well, it depends on what the rest of the board is saying. So right now, I've got some nods going for both what I'm saying and for what Lee's saying. So right now, I'm of the opinion of waiting this out and getting it wrapped up and then bringing it back, because it does not affect your construction in any way. Trustee Trejo is saying, well, he can go with the gentleman's agreement between the attorneys that says that we will wrap this up. We're in concert with the language. We just haven't officially put it down on the paper.
We will.
And so then I'm just looking at the rest of the board to see what thoughts they might have, as we're still in open public hearing here.
I'll just comment on that, though, that it's not a gentleman's agreement. This will have to be in writing, and Jim will have to sign off that what we talk about here that we're in alignment with is actually part of the executed agreement. If that's not the case, they don't have board approval to execute the agreement.
Yeah, what
Fair.
happened is after they complete their original site work under the original annexation agreement, it would come back to the board with no agreement between the attorneys. And then the PED plan wouldn't be approved. So that would be the difference. But if we get everything settled and approved, then it would go to the mayor for signature without having to come to the board, whatever your preference is.
Anyone else?
Other board members, what do you think?
Cheryl?
One of the things we've seen the pictures, we see that the trees are already gone and the construction is already well on its way there. And so what I would want to see is that we're not, by pushing anything down the road here, that we're not delaying that process, that we get to the next step and start getting things back in place so that we can help the situation of
We wouldn't-
noise and so my whole thing is as long as the construction isn't getting delayed so that we move forward to repair back to the backyards of these individuals being back in place here, I would be okay with delaying the 2 weeks.
Okay.
No, I've already given you my opinion. I'm along with you on that. I would wait.
Wayne?
You know, I really entrust Jim to know a lot more about the language and the legalities of it than I do. I would always probably default to Jim, but I could go along with the way the board goes too. If we want to wait a couple of weeks and it doesn't restrict your functionality, I think that's probably the proper way for us to have the final say on it. So I'll go along with the 2-week thing.
Okay, and then Tom, Leah, I know you're.
I'll go with the 2-week thing.
Okay.
So then the motion in that circumstance would be to close the public hearing and
Yes.
to continue items 9, C, D, and E to
Correct.
E and F to the next board meeting for finalization.
Yes.
the amended documents.
So that's C, D, and E.
C, D, E,
And F, right?
F.
Enough.
But you will be able to proceed
Yeah.
with your work under the current annexation agreement. So it shouldn't delay anything for you're doing on site.
Yeah, but the only thing I'm concerned about, and I don't know the answer, so I apologize, is if there's a lender in the wings waiting for plat of subdivision, that could goof things up, but I don't know if that's the case, but if it does, it'll stop. The whole thing will have to get pushed over to the spring.
Is there
I
any
mean,
way
if
we-
any one of these things can be approved tonight without an issue, it's that 9E item, a resolution approving the final plat of Summer. Do you agree with that, Karen? That the approval of the final plat's not going to affect the amendment to the annexation agreement, the final PUD plan?
I would say that's correct. Kristen also just let me know that the developer is dedicating parts of Rosenberg Road right of way to us as part of our reconstruction project. And so this is saving the village some money in acquisition costs. So getting that plat recorded is of a timely essence in order to get all of our numbers in line for the project.
Thank you for that input. In that circumstance, Bruce, we would have a motion to close the public hearing, a motion to continue items 9, C, D, and F, and a motion to adopt the resolution approving the final plat of subdivision tonight.
Which then, that would then have no implications or effect on either the current construction or the potential for any kind of financial considerations that they need.
I guess the answer is I hope so, because I don't deal with the lenders in this instance. They're a big company and you don't let me get involved.
Lenders usually require final plats of subdivision in order to loan, though. That's pretty clear.
Yeah.
Mr. Mayor.
Okay. Bruce, this is
Oh, sorry.
public hearing still.
The public hearing.
So just a comment I'll make. So hearing your feedback, I mean, like I said, I didn't have a strong opinion either way in terms of delaying it or just, like I said, we've done it plenty of times where we give Jim the latitude, assuming we're all alignment with what he's saying. I would be of the mindset that you need to find out that answer quickly if it has any impact on lending. We could call a meeting, as long as we give the public notice, and I'm okay with doing a special meeting this weekend, whenever it needs to happen to get the thing done. So I would recommend getting with Attorney Knippen as soon as possible, iron out whether or not there's an issue with the lending. If there is any issue with the lending, let us know as soon as possible, then we could do a special meeting. And that's what I would recommend. Obviously, we need to be accountable to the village and we need to make sure that we're, finalizing agreements in a timely manner, working with the developers. Obviously, to Karen's point, you guys have done right by us by doing the village right away. So obviously, if there's something that we need to do to expedite the approval of these ordinances to get the lending and the financing in order, then I'm all for it.
I would agree with that, but I would, as what I'm hearing also is the amendment is not the key. They've already got an annexation agreement in
Fair.
play.
I'm saying he's saying he doesn't know, so I just want to
So
say like, if it's not, that's fine. We can just wait the 2 weeks. But if I would say get that answer tomorrow, that way we know, because we do need, what is it, a 48-hour notice period? We need to give the public a 48-hour notice period to do a public hearing or to open a public meeting to pass this. So, I mean, you need to get the answer basically tomorrow if there's any issue with C, D, and F not being passed tonight.
Yeah, because they would be interested, there are many provisions in the annexation agreement that are essential to development. And I would guess that if a lender had an objection, they would not disperse the proceeds of any loan without that. But I don't have the answer, so I'll have to find out. And if it's a big problem, then I guess you'll know as soon as I know.
Fair enough. So any more questions? If not, are there any recommendations to the village board? Seeing none, I'd like to make a motion to close the public hearing for the amendment to the annexation agreement for 7 North 601 Rodenberg Road.
Second.
Roll call, please.
Trustee Berkshire,
Yes.
trustee Trejo,
Aye.
trustee Prokowski,
Aye.
trustee Domke,
Aye.
trustee Lanisa,
Aye.
and trustee Delapenna.
Aye.
Trustee Berkshire.
I'd like to make a motion to continue the ordinance or item 9C on the agenda about the ordinance authorizing the execution of the amendment to the next meeting or sooner pending what we hear back from the development.
Is there a second?
Second.
May I interject? Were we going to go ahead with the plat?
I'm getting.
Correct. We're starting with 9C
I'm
first.
still on 9C. I'm
Oh,
working
We have
my
to
way
get through a
down.
couple more before then. And before I go to a vote, because we're just continuing an ordinance, but it's not the passing of the ordinance, we're fine with a voice vote, correct?
Yes.
Thank you. So we have a motion and a second. All those in favor of continuing 9C to either October 20th or a date sooner, should a special meeting be called, please signify by saying aye.
Yes.
All opposed, nay. Any abstentions? Seeing none, that motion passes.
I would like to make a motion to continue ordinance approving item 9D of the final development plan and plan for unit development.
Is there a second? All those in favor of continuing item 9D to the October 25th meeting or a date sooner, should the board specify, please signify by saying aye.
Yes.
Aye.
All opposed, nay. Any abstentions? Seeing none, that motion carries.
I'd like to make a motion to adopt a resolution approving the final plat of subdivision for Timberleaf.
Second.
Thank you. Any discussion? Seeing none, all those in favor, please signify by saying aye.
Aye.
All those opposed, nay. Any abstentions? That motion passes.
And then I would like to make a motion to continue the resolution authorizing the mayor to sign and the village clerk to attest to the subdivision improvement.
Is there a second?
I'll second.
Any discussion? Seeing none, all those in favor of continuing item 9F until October 25th or a date sooner, please signify by saying aye.
Yes.
All those opposed, nay. Any abstentions? Seeing none, that motion carries.
Thank you, Mr. Mayor. There is nothing else from community development.
Thank you very much, trustee Berkshire. We have nothing under administration tonight or fire. Police, trustee Delapenna.
I would like to make a motion to adopt a resolution authorizing the mayor to execute and the village clerk to attest to an addendum to the intergovernmental agreement 2002-1264 between the village of Roselle and Lake Park High School District 108.
Any discussion? Seeing none, we'll move to a vote. All those in favor, please signify by saying aye.
Yes.
Aye.
Aye.
All those opposed, nay. Any abstentions? Seeing none, that motion carries. We'll move to Public Works. Trustee Domke.
Yes, I'd like to make a motion to adopt a resolution authorizing the mayor to execute an agreement for engineering services for the arc flash analysis of the wastewater and water facilities between the village of Roselle and Power System Engineering Incorporated in the amount of $37,100.
Second.
Any discussion? Seeing none, we'll move to a vote. All those in favor, please signify by saying aye.
Yes.
Aye.
All those opposed, nay. Any abstentions? Seeing none, that motion carries. We'll move to finance.
So I'd like to make a motion to approve the accounts payable lists for October 11th of 2021 in the amount of $847,658.57.
Is there a second?
Second.
Any discussion? All those in favor, please signify by saying aye.
Aye.
All those opposed, nay. Any abstentions? Seeing none, that motion passes. Thank you, trustee Lanisa. Moving to new business, we have a second opportunity for public comment. Is there anyone tonight that wishes to provide comment at this time? Seeing none, we'll move to our first item on new business, July 3rd fireworks. Jason?
Thank you. Before the board tonight's a recommendation to secure a vendor for next year's fireworks. Melrose Pyrotechnics, our current vendor, I reached out to get an idea of lead time on securing the July 3rd event next year, and they recommended we do it as soon as possible. And given our standing with them as a longtime client on that day, they could commit to providing staffing for it. They're encountering some staffing shortages themselves that they anticipate they may have to cancel or not take on as many, events next year. There is a cost increase that would be part of this agreement, and that solely reflects Sorry, the increased cost of shipping containers of about $4,500, which is about half a container. I think he says they're seeing $9,000 to $10,000 increases. So want to see if the board is interested in kind of moving forward for next year's event this early. If so, I would bring back an agreement 2 weeks from now. And I think we would certainly, staff would recommend maybe next year or for 2023, if things kind of the economy rebounds a bit and some of these pressures that are going on now aren't present, to go out to the market and just kind of shop around the agreement. Melrose actually has been acquired, it's my understanding, so that they've been acquired by a new business. So this will be the first year we'll try with kind of the new company, and then can look next year to get this out on the street for more of a request for proposal. I'd happy to answer any questions.
Bruce?
I actually like the idea in getting through it, but will we have some sort of cancellation or out clause?
Yep. So yeah, it'd basically be the standard agreement. I don't have it in front of me, but there are some triggers, X amount of days before you can kind of reschedule, X amount of days, like what happened during the pandemic. That the penalty was carried over to pay for the fireworks the following year. So there are some kind of 30, 60-day milestones that, depending on how much notice, it's either cancellation or it's you have to keep spending the money but just reschedule. So there will be those same provisions.
I have no further questions, or I'm fine with it.
All right, any other questions or thoughts? Wayne?
You said 9,000, but I see 4,500 here.
Yeah, so I took it as a half of a container is our fireworks. So he said about $9,000 to $10,000 a container. Our portion of that's a half, is 4,500. So that was kind of how.
It's actually cheap for a container right now. We're paying up to 16,000 just to get them in from overseas.
So, but I'm totally for going out to bid more often next year. In many of different areas, we've maybe fallen in love with some of our vendors, and I think we should hold them to the coals and see if they really are giving us the deal they say they're giving us.
Yep, I think that's good feedback. I think, staff's been really great about trying to figure out how we balance from the pandemic to trying to get back out there. I think we'll start to see that, but it'll probably have to be phased out just because of the time that staff requires. So, but thank you so much. Lee?
Just a question on this, though. I'm obviously, since things are moving very quickly with shipping rates, I mean, they could fall dramatically pretty quick too. So is there a way to put like a de-escalator in there where the amount would change based on the shipping rates? Or I don't know if that's been talked about or not. Like, I don't know if this is like the final price, like that's it, or if driven up because of that.
I don't know if this is quantities they already have on hand. They've already paid it, right?
That's the thing.
Which, I'd have to ask more. I didn't get into that much detail. I can certainly find out a little more, get a little more transparency around it.
And I guess is there protection against further increases too? Because I mean, who knows what's going to happen? I know I was talking to a supplier today, and like a semiconductor went from $3 to $105 in a year. So, if the 32,000 is just the price, no matter what it costs them to get it here, if they don't have it here already, then each side's taking a little bit of a risk. Then I'm more open to just approving that amount. But it would be good to get that feedback.
Okay. Any other feedback or questions? All right, so staff has their directions to bring it back, and I'd say just any additional research we can provide as far as those opportunities.
I will do that.
Given it's a year, depending what we get back, it might be okay just to ride it through until we do go to bid though, hopefully, so.
Yeah.
All right, next item, Metro 19.
Yep, I just want to provide the board an update on Metro 19 since things are starting to be publicly noticeable relative to the status of the project. I think most of you know, from the very beginning, this has kind of been a complex agreement, multiple agencies involved, landowners, financing tools, development techniques. So really the village and developers teams been in contact pretty much weekly just to provide updates and work through some ongoing kind of issues that arise. I think at this point, their occupancy probably wouldn't be till 2023. So just the main status really are the land acquisition and easement dedication, which the board approved in July. Closing on that is Wednesday. There was a bit of a delay there with some title issues, but we worked through that. So that will be secured on Wednesday. That then allows the developer to start construction on Rose Drive East expansion next week. Signs are already up for that relative to the Rose Drive East entrance being closed because that land being acquired as part of the Sternberg property there will be used for the expansion. So detour signs will be posted. We'll work through some of the PR side of it. Fortunately, that parking is certainly down up there from the heyday. So there's certainly less commuters that will be disrupted by this just based on the volume of commuters being reduced. They would like to request Saturday work hours if necessary, based on the pending kind of winter weather and our interest in that entrance really needs to be completed this season. So they are requesting kind of upfront the ability to work on Saturdays if necessary. And that's only for the Rose Drive East area. The developer will soon start to also develop the Sunrise Courts, which was the Ray Graham Association property. They already have a permit approved for that. That's all on their property. So they could do that now if they wanted to, but I believe they're aligning the work to start there and Rose Drive East next week. The land exchange with Metro, which the board approved back in January, has been a protracted title search process there. We believe we're over the hump, but I will ask Knippen attorney to send another email to Chicago Title tomorrow on our behalf, inquiring on the status. We're pretty close from our understanding of our last phone call with them, but like everything in the world, things seem to be moving extra slow nowadays. So once that is done, that then will allow the developer to start work on the daily fee lot, site work, which will basically be the foundation for the garage then. So getting that property swap with Metro is really essential for the actual building construction to start there. The parking garage, as I said, will be on kind of the parcel exchanged with them. And that also includes the underground stormwater detention will be underneath the garage. So their hope is to get some sort of foundation poured this season, whatever season that is, if that's something they can still do in the winter, as I believe we would start to see some of the garage components coming together, the prefab, probably spring of next year. Also, the installation of sanitary force main has been approved by the village. I don't know if IEPA has now approved their permit for that. So I believe they're ready to construct, and that again would be in the spring as well. And then the undergrounding of electrical utilities, staff has been working very closely with Metra and to get some ComEd paperwork processed and approved so that they can complete the undergrounding of utilities there. So next steps really for the village board would be ultimately an amended and reinstated redevelopment agreement. That's really what the attorneys have been working through, taking the one current agreement, making it to nothing changes financially or any role, any responsibilities. It's just the developers now created two LLCs, one responsible for different components of the project, one being the residential, and then the other one being all the public improvements, the garage, the Rose Drive East, the force main. So we're just working through that process. When those agreements are back for the board to final approval, there will also be a need for the board to consider issuing the alternate revenue bonds in the amount of $14.5 million, which is the funding mechanism which to reimburse the developer for some of these public improvements. The Rose Drive East would be the first one that the village would have to approve. We're getting an estimate from the developer on what that dollar amount will be, but that would be reimbursed probably within 90 days. I believe we have adequate cash on hand and other funds to cover that. But the force main then would be the next piece reimbursed next year. And that's when the bonds would be necessary to help cover those costs for those public improvements. And then the large lump sum of $11 million would be due when 50% occupancy of the apartment complex. So that's out certainly a year or plus. So I just want to kind of give the board public an overall update on the project. It is progressing forward. You're starting to see some signs, construction coming soon. I'll certainly we'll keep the public and the board up to date as things continue here and a little more information for the community to understand some of kind of the detours and other impacts of the work being started. with that, I'm happy to answer any questions.
Any questions or comments from the board? Wayne?
How do you keep the public updated and what do you tell them?
Well, certainly, well, I think we can work with the mayor on that. I don't know if we're gonna, a groundbreaking sure would be nice. I don't know when that'll be. So that would help with some sort of just announcement. And then we also need from the developer estimated construction schedule that's updated.
Estimated and tentative, those words, if you use them, you won't be eating them
Yes.
later on.
Yep. So I think the developer owes that. Well, one, to me, the board still needs to approve the amended in agreement. I think when that's done, then we can kind of solidify the dates moving forward and we can communicate that out to through the Roselle Reporter and our other means with those kind of tentative estimates, be it seasons or years, just so they have an idea of kind of what's coming up in the next 18 to 24 months on this project.
Just because you don't hear them, the question, they're out there.
Yep. Yeah, and we've done our part to try to respond to some of that with some of the coming soon, that it still is working, some of the advanced notice on the detours.
Even the tentative occupancy, when you say 2023, that tells people something. Anyway.
Yep. So we'll work on firming up those kind of expectations and anticipated deliverables with the developer. Once we kind of have that, I think, amended and reinstated agreement reapproved or approved by the board. And I think that'll be a good launch pad moving
That and the
forward.
mangy dog and the relative brewery, and people keep asking about that.
Yeah,
They're excited, you know,
Yeah.
and then they don't see anything for years or months.
yeah, well, yeah, that's
Some of that's
Some of
not,
that's-
we don't know either.
Yeah.
So
I know.
that's the trick, right?
just because the board approves something doesn't mean the developer is going to move forward with it, is sometimes the case.
Oh, I get it. I get
Yeah.
it.
Any other?
Whenever we can.
Yeah, absolutely.
Understood.
Any other comments or questions?
You know, I would like to just say something about people that come here and too bad they left. You know, we're not against trees or
Well,
keeping the place.
Why don't we do this under other business real quick, if that's okay?
Okay.
That's okay with you, Wayne.
Okay.
Just last call for that, Metro 19. Just want to make sure no one got cut off. Okay. With that being the case, we've completed our new business. So other business. Yes, Wayne.
Oh, wait a minute. I forgot what I was gonna say. No. You know, we're not against it either. And I think sometimes we come across as like we're just some bureaucracy bulldozing somebody's trees down. But you know, if you live next to an open field, there's a chance that somebody's gonna put something there. And sometimes the thing that's coming is a better thing that could have come. So, you know, they're gonna improve in hopes the road gets improved from what it is now. Crosswalks might be improved because we got more people using them. You know, you're gonna do something that's gonna solidify some ground and it's gonna dedicate the other ground for a purpose and somebody's gonna try to take care of it. Whereas opposed to, like, you had a picture of willow trees being chopped down. Well, yeah, they're gonna get chopped down for a while, but then other stuff's gonna go up there and it's gonna look nice. It's gonna look landscaped and well-developed. But it's not gonna be rural Roselle anymore. You want rural Roselle, you gotta go out to Elburn or Union, Illinois. There's no way you're gonna redo rural Illinois or rural Roselle. But, you know, I get the whole premise, being with the history community and everything of how it used to be. But we need to move forward with stuff, and empty land will get developed. So, you know, I don't mean to be mean to them, but they should have known. You're not gonna have that open field. I didn't have an open field next to my house more than 3 years, and all of a sudden it became a retentions, and then there were houses. But it does look nice now. So anyway, sorry, I didn't want to go off on anybody, but I think sometimes we sit up here and we take it and we don't give them the impression that we care, you know, so. It's unfortunate, but we should have probably told them all that this is Tree City, for gosh sakes. We must like trees. So anyway, I'm defending us. We're good people.
All right. Any other business tonight? Seeing none, we have no executive session. Do I have a motion to adjourn?
Moved.
Is there a second?
Second.
All those in favor, please signify by saying aye.
Yes.
Opposed, nay.
I want to talk a little bit more.